Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Malter. Michael is a bankruptcy attorney, partner in Binder and Malter LLP. It's a boutique bankruptcy firm that's located in Santa Clara. He's been there for about 34 years, or been in the law practice anyway for 34 years. He graduated with a JD degree from the University of Santa Clara School of Law in 1980. He is a certified specialist in bankruptcy law through the State Bar of California Board of Legal Specialization since 1995, and he's been an adjunct faculty member at Santa Clara University School of Law since 1985. He's been named a super lawyer of the U.S. And California by Thomson Reuters every year since that recognition was first awarded, which is in 2004. And he's a founder and past president of Congressman Don Edwards' Inn of Court, which is a chapter of America's Inns of Court. And he has 2 teenage daughters, but it keeps him hopping. And his outside interests include labradoodles and hiking. Mike, thanks for joining me today.
My pleasure, Michael. Nice to be back.
Okay. Today, Michael and I will be talking about what you should know about corporate bankruptcy. This is a new subject for us. As we get started, I'll caution our viewers that bankruptcy is a complex area, and definitely you'll need an attorney when you get involved in this process. On the other hand, there are people that are facing challenges, still going through the recovery and so forth. So we wanted to bring some information to you, some basic information for a further discussion with your own attorney. So Michael, again, thank you for joining me today. What are some of the different types of bankruptcies available to businesses?
Well, there are different chapters of bankruptcy as provided for under the Bankruptcy Code. The Bankruptcy Code is federal law, so this discussion would be the same no matter what state we were in. And basically, the Bankruptcy Code is a book, and the chapters we refer to are chapters in that book, so not too mystical. A couple of the chapters we'll kind of dispose of quickly for business bankruptcy. One is there's a type of bankruptcy called Chapter 13, which is a form of a payment plan. Mm-hmm. But Chapter 13 is only available to sole proprietorships, individuals doing business, as opposed to corporations, partnerships, or other types of fictional entities, which we'll really focus on this afternoon. There's also a type of bankruptcy for the family farmer, another type of business. That's called Chapter 12. It's very similar to Chapter 13, and again, we really won't spend much time on that today. The main chapters available for businesses, and this would be true for corporations, LLCs, LLPs, any form of fictional entity, are either Chapter 7 or Chapter 11. A Chapter 7 is a liquidation proceeding. Chapter 11 is a reorganization. And I would like to comment that in regard to these entities, corporations or other fictional entities, they can only file for bankruptcy through counsel. So the corporation can't represent itself. It must have counsel in federal court.
Okay. So how do these chapters, Chapter 7, which you said was liquidation, is that right?
That's
and then
correct.
Chapter 11 was reorganization. How do they operate? Who runs the show?
It's an important question. With the filing of a Chapter 7, which again occurs with the federal court, immediately upon the filing of the Chapter 7, the court appoints someone called a trustee to every Chapter 7 case. And essentially, the trustee takes over the business immediately. There's a literal handing of the keys to the Chapter 7 trustee. The business is shut down. It is no longer operating. And it's then up to the trustee to ultimately conduct the liquidation. Conversely, in a Chapter 11 filing, there is no trustee. Chapter 11 filing is called a debtor in possession case meaning that typically whoever was running the business the minute before the filing continues to run the business after the filing. They remain in control, in management, unless circumstances warrant that they should no longer be in that position to do so.
If they weren't in a position to do so, would they change the chapter then? Would they switch to Chapter 7?
That's one possibility. A case can be converted from Chapter 11 to Chapter 7 if there's mismanagement, but a more ready tool to protect the creditors is that the court can appoint a trustee in a Chapter 11 case.
Okay.
It's frankly unusual. It's in circumstances, again, where there's been mismanagement or misoperation of the business. But the goal of the court really is to safeguard the creditors, to make sure that ultimately they will get the best possible return. And often that's going to be done in Chapter 11 while the business continues to operate, whereas in Chapter 7 where it shuts down.
Yeah. Okay. Well, why would a company choose Chapter 7 instead of Chapter 11? So you're going for, I guess, the liquidation where you're saying you're going completely out of business.
Right. Well, first of all, in a Chapter 11, there's an assumption that the company has the ability to meet all of its ongoing financial requirements as they come due. So in other words, after the filing of the Chapter 11 of the bankruptcy, the business has to pay rent when it's due and in full, pay all of its obligations going forward on a timely basis. And some businesses simply can't do that. If there's not cash coming in with which to pay suppliers or pay necessary creditors like the landlord, there's just not an ability to operate. The second reality is that Chapter 11 is far more expensive than Chapter 7. A Chapter 11 reorganization was designed by Congress with mega corporations in mind, so that, for example, Chapter 11s that we're all familiar with would be American Airlines has been in and out of Chapter 11. Macy's has been in and out of Chapter 11. PG&E was in Chapter 11. Enron was in Chapter 11. And so, you hear these very large corporations. And unfortunately, when Congress devised Chapter 11, it didn't change the requirements as to what needs to happen if you're dealing with a small corporation or a mom-and-pop corporation versus a mega corporation like PG&E. So the debtor in Chapter 11 has to jump all the same hoops. That requires a great deal of attorney time, and great deal of attorney time times hourly rate is big fees.
Big money, yeah. Wow. So I think one of the ones that was, I think, a surprise to people recently because of the economic downturn. Again, didn't General Motors also have maybe a Chapter 11? Or?
Yes, well, the auto industry, it looked like the entire auto industry might go into...
Ford would manage to stay out, but I think everybody else went in. So.
Yes, and it's a great example, though, Michael, of where the threat of the filing of Chapter 11 ultimately forced the bondholder and the other stakeholders to basically make concessions to keep those companies alive. And sometimes the threat of the filing can be very effective in negotiations.
So how are business bankruptcies similar to individual bankruptcies?
Well, they are similar in that with the filing of the case, and this is the most significant aspect of bankruptcy, upon the filing of the case, whether it's an individual or a business, there's something called the automatic stay which comes into effect. And the automatic stay, which is one of the few terms of law that is what it sounds like, automatically stop any actions against the debtor, so that the second the bankruptcy is filed, there cannot be any further lawsuits against the business. There can't be any collection activities against the business. If there's a trial, the trial stops. If there's an eviction, the eviction stops. A foreclosure stops. Everything stops with the filing of bankruptcy. And that's one of the most significant aspects of a bankruptcy filing, whether for individuals or for businesses.
Okay. So then what happens in a Chapter 7 case?
Well, in a Chapter 7, basically, the bankruptcy trustee, again, that individual who was appointed when the case was filed, is going to immediately take stock of what assets are remaining in the business. And that can range from accounts receivable to inventory to equipment. And the trustee is also going to look to see who the constituent creditors are of the case. And the first big question is whether there is a secured creditor. So a secured creditor, for example, is the bank that may have provided the financing for the corporation. And in many cases, the lending institution will take what's called a security interest against everything.
Against everything?
Yes.
Okay.
And it's called a blanket security interest, and it'll be against the receivables, the inventory, the equipment. Very often they get a guarantee from the individual, firstborn, anything the bank can get. And if the amount owed to the bank is greater than the value of all of the assets, then basically the secured creditor is going to wind up with everything. Mm-hmm. On the other hand, there are businesses where there is no secured creditor, or the amount owed to the secured creditor is less than the total value of all of the assets. And that's a case in which the trustee is going to liquidate the assets to pay the secured creditor and then to pay the other creditors of the bankruptcy estate as is prescribed by the bankruptcy code.
Okay, so it sounds like in the situation where there's the secured interest that's more than the assets, that's going to be a shorter process than where you've got other people that you need to also settle with.
That's exactly right. And in that situation, the latter situation where there are assets to be liquidated for the benefit of other creditors, the bankruptcy trustee then looks to the bankruptcy code to see the pecking order of who gets paid. So that this will, I know, enormously surprise you, Michael, but the first creditor to get paid after the secured creditor is the Internal Revenue Service.
Oh, okay.
This is federal law. The federal government doesn't really care about credit card debt or unsecured debt, but they do like to take care of their own income. So taxes will come next as what's called a priority claim. Wages enjoy a priority up to $14,000 per employee, mm-hmm. and then after that comes all of the other general debt.
So this isn't really near, but meanwhile, I mean, there are expenses that are being incurred in this process. So, for example, we know the legal fees. So, how does that weigh into all of this?
Well, typically the attorney for the debtor, the attorney for the party that filed the bankruptcy, is not paid out of the bankruptcy estate. They're paid prior to the bankruptcy by the debtor. The trustee, however, is on a commission, and the trustee also has the right to employ professionals. So if there are assets above and beyond what's owed to the secured creditor to liquidate, the trustee will receive a fee and also have dollars with which to pay an accountant or counsel they may need to bring in.
So does that have priority over the, let's say, the tier after wages or whatever?
Yes, actually it has priority just under secured debt and over everything else.
Oh, so even before the Internal Revenue Service?
Yes, because without those professionals, without the services of the trustee of the professionals, there wouldn't be anything for anyone.
Okay. So, just wanted to clarify that. Okay, well, now, what about a Chapter 11 case?
So, in a Chapter 11 case, again, there is no trustee. Mm-hmm. And in a Chapter 11 case, the goal is ultimately for the debtor to put together a plan of reorganization, a blueprint, as to how the debtor is going to provide for payment to creditors. This plan of reorganization can take a million different forms. It's really can go in as many directions as creativity will allow. But it can be anything from the debtor using profits over time to pay its creditors. That's called a bootstrap plan, as in picking yourself up by your bootstraps. It could be that the debtor is going to sell the business, sell some of the assets of the business, do a merger, do a joint venture. It can go in many, many different directions. And ultimately, the debtor proposes to the court something called a disclosure statement, which is the story of the company. And then when the court approves that, the debtor then sends out this plan of reorganization with the disclosure statement, the story, and a ballot. And the creditors will actually vote up or down as to whether they want to go along with the plan that's been proposed.
Okay. Do the creditors actually have a creditors meeting where they get together, or is that just sort of an ideal?
That's a very good question. Right at the start of the case, in the first 30 days, creditors are invited to a meeting with the debtor that's presided over by the U.S. Trustee's Office at the Bankruptcy Court. Separate and apart from that, the 20 largest creditors of the company will be invited to form a creditors committee. And that's very typical in these cases. And the idea is that the largest interest holders will look out for everybody. Mm-hmm. And the creditors committee has the right to hire its own counsel, its own accountant, and operate as a sort of board of directors to the debtor in bankruptcy.
Okay. So maybe you can tell us a little bit about an example of somebody that you've helped with this process.
Well, we've had a very recent interesting case. In March of this year, 2014, my firm filed a Chapter 11 for a steel company. And at first I thought this was a joke, that the steel company is in Berkeley, not necessarily known for industry. Mm-hmm. But in fact, it's an 85-year-old steel company, third generation, employs 500 people. The company was experiencing losses. It was beset by issues with its union. There was a class action lawsuit for $30 million. There were some very substantial issues. So we went into Chapter 11 with that company. It was determined that the best return to creditors would be through a sale of the company. We conducted an auction. It was a nationwide auction, and were successful in selling the company. 500 jobs were preserved, and the business will be going on, hopefully, for many years to come.
Wow. That's one of the nice ones, huh? It's not at all that nice.
We had another one that was pretty well known locally here in San Jose with a chain of Hispanic markets called Mi Pueblo. Mm-hmm. And again, that was a very successful reorganization. Those stores continue to operate throughout the South Bay.
That's great. So I've heard that there's actually a high failure rate for Chapter 11 cases, like 90% end up in Chapter 7. Is that the case, and why do you think that's the case?
Well, the national statistics on Chapter 11 are every bit as gloomy as you just stated. There's a very high failure rate, and failure usually means the case converting to Chapter 7 and just going into liquidation. I'm very proud to say that my firm has the reverse statistic. Our success rate is around 90%. And in addition to the obvious brilliance that we bring to the game, is honestly the fact I fault bad lawyering on those terrible statistics.
Really?
Yeah, I think that it is when a company presents itself in distress, it's very easy for a law firm to say, give us a large retainer, we'll get you peace today. You know, we'll stop the eviction, we'll stop the foreclosure, we'll stop the lawsuit. Sounds great. But the question that has to be asked is, after that peace has been gained, how do you get out of Chapter 11? What is the exit strategy? Mm-hmm. And it's our philosophy that you need to know what the plan of reorganization is going to be before you file the bankruptcy. Because, you know, once you're in Chapter 11, it's not as though you're mystically going to suddenly ordain what the way out of the case is. You need to have a very solid business plan, and a good bit of thought needs to go into how you're going to get out of the Chapter 11. Going in is fairly easy if you have the money. Mm-hmm. Getting out is the different process.
Yeah, it's sort of like when you set up a corporation in the first place. It's easy to set one up. It's harder to finish it up.
That's exactly right. But it also speaks to the fact that if Chapter 11 is at all in contemplation, the more lead time the attorney can have to work with the client, the better. The more thought that can go into business plans and figuring out what the restructure will look like, the better. The odds of success just go up proportionally with the amount of preparation.
Okay. So we have, I think, a little time left here. I'm not quite sure exactly what, but one of the things, since I'm the tax person, so as I understand it, an advantage of bankruptcy is that if you have like a debt cancellation in bankruptcy, that it's not going to be currently taxable income. Is that right?
That's right. But timing is everything.
Okay.
So the timing needs to be such that the debt forgiveness occurs in the bankruptcy.
When it's happening. Yeah.
Right, so that there is a discharge of that indebtedness. And this, of course, was a very hot issue in the last several years during the real estate downturn. There was quite a bit in the way of debt forgiveness, and folks didn't realize that they would be hit with this cancellation of debt tax.
Right. And a lot of people, though, even if they do have the tax-exempt income, if you will, they don't know that there's going to be a basis adjustment that's going to happen as a result, or adjustment of other tax attributes, like net operating losses will be reduced and so forth.
That's exactly right. And I'll tell you, I would not approach any, especially Chapter 11 leveled, sophisticated reorganization. I will not step foot into one of those cases without an able CPA like yourself alongside me. I'm not an expert in taxes. I've come to learn more than I thought I needed to know, but I'm always going to have somebody of your level of expertise with me to make sure none of the tax angles are missed.
Okay. Mike, we actually have about 5 minutes, so maybe you can either, or both, share a story and some words of wisdom, maybe to give some additional information to people here.
Well, thank you. You know, I've just seen, in 34 years of doing this, there have just been so many changes. When I started out as a bankruptcy attorney, the biggest threat to my clients were interest rates. And that I came on board when, it was not uncommon to see 18% interest rates. I'm sure you remember those good old times. And frankly, right now we're enjoying good interest rates, but my assumption is that what goes down will go back up. I think it's a real concern, and so I think being cognizant of the fact that everything is cyclical. Low interest rates will beget higher interest rates in the future is something that I've learned. And just the whole cyclical aspect of all of this is also very, very true and very real. In 34 years, I think I've seen 3 very, very significant valleys. One of them was happening when I first became a lawyer in 1980, but then we saw it again in the early 90s, and then, of course, recently with the Great Recession. So, you can't ever plan enough for the future just because of the fact that good times last just so long. Luckily, bad times last just so long, too. And I do think that what I've seen in my practice is a more sophisticated clientele. The Bankruptcy Code, by the way, was only enacted in 1979. So bankruptcy law, as we now practice it, is fairly new law. And when I remember when I started out and I was dealing with older clients, they thought of bankruptcy as a ticket to a leper colony, that they thought that was just the end of the world.
You're going to have a stigma over your head for the rest of your life.
Right,
yeah.
Inescapable. And I think that there's a much greater realization today that bankruptcy is a tool that's available to businesses. Still, of course, nothing anyone would ever take in a lighthearted manner. But it is a viable business tool. Life goes on for those who have to file bankruptcy. The filing of bankruptcy by a business, a corporation or LLC, does not impact the individual principles of that business. It's not a taint on them. Many great Americans have had to file bankruptcy for corporations and then rise again. There are many, many well-known names.
Right.
So,
I think Abraham Lincoln was one of them, but anyway,
okay,
maybe not a corporation, but I think he had a personal bankruptcy of some type.
I think Harry Truman was as well,
Okay.
and Walt Disney, and there are many significant members of our society. And the American ideal, which I cherish, is that we encourage entrepreneurs. We have a right to fail. Mm-hmm. And that if a business fails, and businesses can fail for a million different reasons, if a business fails, we believe in the opportunity for the individual to pick themselves up and go try again. And that's part of what makes this country great.
Right. So I guess some people might say, if you haven't had a bankruptcy, maybe you're not really trying. Well, anyway, I appreciate your thoughts and this information. And thank you for joining as my guest.
My pleasure.
Folks, I hope we've given you some good information, basic information to think about. You may be facing a financial challenge in your business right now. And so if that's the case, that's what legal counsel is for, basically to counsel you, to be there and to be your advisor. And like Mike said, you actually may want to bring other people into the party, like your CPA and so forth, to put your heads together and work through the problem. So with that, we'll see you next time on Financial Insider Weekly.